Number 45, the people of the state of New York versus Robin Pena. Counsel?
Yes, Your Honor. Good afternoon, and may it please the court. Paul Anderson for the people. May I reserve 2 minutes for rebuttal?
Of course, sir.
Thank you. The key issue here, Your Honor, is how do we evaluate what is a reasonable reading of the equipment statute in the VTL?
I want to stop for 1 second before we even get there, which is, in this particular case, the officers never actually issued any simplified traffic information, and the accusatory instrument that was ultimately filed doesn't list any VTL equipment-related offenses. So how do we determine how to even begin that analysis when we don't know either objectively or subjectively what the officer had in mind as an equipment violation?
Well, first, the record shows on page A90, there was a defective brake light. Is that a vehicle and traffic law infraction? Is that the reason you pulled him over? Yes. So we know that those facts were the objective facts there were the reason to pull him over. What we don't need is in the officer's subjective mind, what exact VTL violation in his mind. One, because that would lend towards a subjective standard. And two, it goes against Alfred and Devenpeck, which this court cited favorably to in Reed, and that what we look at is what the facts the officer testifies to. And here the facts the officer testifies to, which in A16, A17, he clarified it was the middle brake light. A117, 116, he clarified it was the middle brake light. And then we had legal arguments that followed of what statutes apply and what would be a reasonable reading of the statutes. Here, the court stopped immediately at 375-40 sub B, which would be just the equipment part of the lighting scheme, to say, but completely ignored when the prosecutor offered, Your Honor, that's actually not all that applies here. If we look up to sub 19, that talks about how you maintain the lights. And in fact, it refers to 376, which goes further and says, these lights, if any vehicle that is not so equipped with or has defectively equipped with these lights would be a violation. So here the court said, no, no, no. We have to stay at 375, sub 40, which is what defense counsel argues. It's unambiguous. However, is
it fair to say that 375 governs what equipment must be on a car and 376 governs what equipment must work?
That would be fair for the light signaling devices, yes, Your Honor, because 376 is specifically towards lights, but then it gets referred back to. It's tough to paint 375 in such a broad brush because it's everywhere. There's 53 subsections that ranges from how school buses get equipped. But that is a correct statement that this is what is required on a vehicle, and then you look to see how you maintain it or how you have to keep it maintained. And that's consistent with the North Carolina statute with the Supreme Court held in Hine. There was the part that said you must have a stop lamp, and the singular plural, that was the cause of issue.
On the maintenance part of it, right, doesn't the North Carolina statute say all?
Yes, the second part.
And we don't have that here.
Well, we don't, yes, Your Honor, but what we have is, it's still not restrictive language. Well, yes, North Carolina went further and said all equipment. It's not like New Jersey or Kansas in the cases I cited, State v. Lee and State v. Sutherland, in which you had the equipment statute, and then the maintenance section had restrictive language of only the lights that are required by the other section have to be in good order. There is no limiting language in 376 at all. It's if you have a vehicle that has defective lights, that is enough. Then that is a reasonable reading, and that was the reading that the Second Circuit had in U.S. v. Felton/Davidson, and that was a pre-Hine case in which they said, yes, reading all of these statutes in harmony, this vehicle that had a broken taillight and which was one of the broken brake light and one of the paired assemblies in the left. One was still working, so it was still the at least two language was fine. But the Second Circuit and the Eastern District said, actually, no. This statute, read together, says that any time there's a defect or any light that's defective, that's enough to initiate a stop.
As a general matter, how do you determine which statutes to look at?
Well, Your Honor, you read them all together. I guess looking generally.
So you have to go through every section in the VTL, or?
Yes, Your Honor. It's similar to, I guess, being in the complaint room or drafting a complaint. You have these facts in front of you, and you match to what elements hit it or what applies here. And that's, you can see in the hearing, that's what the prosecutor did. The court asked, what statute applies to brake lights? I think and then the defense counsel said, no, I think it's only the 375 sub 40. Prosecutor asked, let me get that more time to research after the break, came back and came forward with this analysis, which while they didn't cite to the secretary, it's matched nearly identically in that we read all of these together. And especially when the statute itself tells us, and I think VTL 300 says, the entire title applies to any vehicles driving in the state of New
Well,
York.
would you agree that if we were to just look at 375 and 376, that alone creates sufficient ambiguity to say this was a reasonable, an objectively reasonable mistake of law?
Yes, in fact, as the prosecutor noted below in their final argument on page 171, they actually said, Your Honors, he actually could have issued a summons for this. And he changed course or she changed course somewhere and said, that's a ticketable offense. Technically, any lamp that's out is a summonable offense. And so reading that all together, and especially in the absence of case law interpreting this specifically, yes, we had Bookman, which I think was the dissenting judge, and also I think was decided weeks prior to the stop. But once again, that only looked at 375 in itself, in a complete vacuum. And that's the same thing that happened in U.S. v. Mota, the federal case that happened after the hearing here. And in fact, I've re-looked at Pacer and to see what arguments were raised. The only arguments were raised were just how 375 sub 40 applies. There was no discussion as to 376 and no reference to which I guess would have been a binding authority on Mota.
Does the VTL require that the third brake light, the center light, be operational? That is this a mistake of law, a reasonable mistake of law, or is this not a mistake at all?
Having reread and read this all over, it's completely ambiguous one way or the other. I would still argue that since no one has decided or no court has definitively decided how 376 applies, this still could actually be a violation of the VTL in that here's a light that's defective and not in working condition.
But we don't necessarily have to decide that it's a violation of the VTL for you to prevail.
Absolutely not, Your Honor. You could just say this is a reasonable interpretation of the statute. We don't have to decide this today.
Counsel, for a moment, did the trial court have the authority to dismiss the accusatory instrument after the people filed their notice of appeal?
No, Your Honor, it did not, especially when the reasoning was for suppression of evidence going forward. There's plenty of case law saying that is outside of statutory authority of when you're allowed to dismiss a case. And so when the court had our notice of appeal and knew we were re-arguing and then just dismissed it kind of on the fly, not too sure if it was already dismissed or not, the record is very unclear exactly what was communicated to the judge during that proceeding. But absolutely not. This should be remanded to the appellate term.
On that point, if you actually look at the court action sheet, it says dismissed and sealed, and it's initialed by the judge. Is that an appealable paper?
Yes, Your Honor, it should be. It's because it's still a decision decided adverse to us, adverse to the people, and we filed our supplemental notice of appeal to include that.
And one further point on this. Looking at the order that was signed by a judge of this court granting the people leave, and you're looking at the description of the order, doesn't it really just limit it to the order affirming or the granting of suppression?
No. Well, what happened there, Your Honor, is because the appellate term didn't reach the question of the dismissal, it dismissed it as academic. So it just rendered it based on the suppression decision. So here, I guess this court can really only decide the suppression issue and then remand to the term to consider the appeal that was proper.
Why isn't it academic?
It isn't academic because, it was rendered academic because after suppression, at the time, we would have conceded that if there's no possibility to get this evidence in, just for that case only, we wouldn't pursue it further, or we wouldn't try to go any of the other pathways that would be authorized by 450-50, such as additional evidence that was discovered, or any of the other possible ways. In the facts of those specific case, I think, dropped a footnote saying, should this be ultimately suppressed?
So procedurally, what you think should have happened is once the 450-50 notice is filed, the case is basically paused, if you will, and, carries on the calendar of the criminal court until such time that the intermediate court rules.
Yes, Your Honor, and that's, based on my experience, is what happens in those types of cases.
And getting back to the appealable paper, isn't an appealable paper usually taken from a motion that's, an order that's issued pursuant to a motion, and here we don't even have that motion? You sort of have the court going off sua sponte?
Well, yes, Your Honor, but there is still, these types of issues have been appealed from before, where a court has summarily dismissed based on either an oral application, which this could be construed as, Your Honor, it should be dismissed. I think that was exactly what the defense counsel said at the hearing. And the court says, okay, but it was still somewhat of an oral motion to dismiss, and that we've appealed from those before in the appellate term, and they've granted the appeal, reinstated it. It is murky here, I agree, and procedurally complicated, but once again, when we filed a notice of appeal, we filed an additional supplemental
But
notice
if you
of appeal.
prevail on the suppression issue,
Yes.
do we really need to reach all these other issues?
This court would have to, should remand to the appellate term, so then they
Or
can
do we have to
address.
remand it to them, or can't we just remit it back to the criminal court for further proceedings on the accusatory instrument?
I mean, this court could do what it wants, I'm thinking in my head, but I think the proper,
Always a safe answer in the high court.
I think the proper way would be just to kind of keep it smooth on the correct track, to go down, give the appellate term the opportunity to address this outstanding issue, and then eventually we'd go back to reinstating the instrument. But because right here what we had is the appellate term just address the suppression issue, declined to reach anything else, declined to reach this academic issue, declined to reach the motion to re-argue because it lacked jurisdiction. And then here we are just on the suppression issue. So that's, I guess, how the procedural, in my mind, how it would go, that I'd come back with the term, assuming that this is a reversal, I'd come back to the term saying, can you please address this outstanding issue? You should reinstate the instrument because it was dismissed erroneously, et cetera. And then if I prevail there, then it goes back to criminal court for further proceedings on the instrument.
Thank you, counsel. Counsel?
Good afternoon. My name is Morgan Everhart. I'm from the Bronx Defenders, and I represent Robin Pena. The Constitution protects us from unreasonable searches and seizures. New York protects drivers from being stopped, pulled over, asked to step out of the car, unless, of course, that stop is reasonable. Robin Pena was not stopped because he broke the law.
So putting aside the VTL, what's so unreasonable for somebody to say, pull over because I just want you to know your light's out?
Certainly, and I think this court addressed that issue last week in People v. Hinshaw. When an officer is going to effect a stop based on solely a traffic violation, as the officer testified very clearly here, the only basis for the stop was this perceived broken middle brake light. In that case, this court has already indicated that there's not the same governmental interest for preventing crimes in those for traffic infractions as there are for.
But I think the judge is asking you, what if that's a safety stop? Your light's out. Somebody might run into the back of your car.
Certainly, and it's a question here of what is the purview of police officers in this case. Police officers are charged with enforcing the law and with traffic infractions. And the question about a safety stop, we have civil mechanisms to enforce that. That is the purpose of, for example, annual inspections and DMV mechanisms.
Well, but an annual inspection comes annually. So if your light is out and you've just been inspected last week, there's no purpose to stopping a vehicle to let them know their light's out?
So I think it's important to note the level of infringement that this kind of traffic stop has. This court noted again last week that it is an elevated level, especially when based on a traffic infraction. So in a case where we are seeking suppression, I think the evidence can be suppressed from a stop that is based on a safety concern.
What do you make of the DMV regulations, which Section 376B authorizes the commissioner to promulgate regulations, And the DMV has regulations that say that 1987 newer passenger cars must be equipped with a stop lamp on the vertical center line, and has a regulation that says all stop lamp bulbs or original equipment must light.
Certainly.
And then 376-A, which authorizes officers to issue citations, say that an officer can issue a violation for any violations of 375, 376, or 381. So does that draw in 376B, which has those regulations?
So I think there are many answers to those questions. The first is that there's nothing in the record about whether or not Mr. Pena's car falls into the 1987 or thereafter cars that are subject to that DMV regulation. There's no year of the car that's in the record as far as I'm aware. But even if his car did fall into that category, we don't ask officers to enforce DMV regulations. We ask officers to enforce criminal laws and the vehicle and traffic law. And we ask that officers know the law. In this case, the officer was mistaken about what the law required. And the VTL here is very clear. 375-40B defines within the subsection that statute applies when those lights are illuminated when stepped on the brakes. So within that subsection, it says that you've got to have one on either side, which Mr. Pena had, and they've got to be on when you step on the brakes.
Well, if that was the only provision of the VTO that dealt with lights, then we wouldn't be, right? So but we know that there's another provision, at least one other provision.
Yes.
There are maybe more than that, but at least one other provision. And in my view, the provision isn't entirely clear. We've heard about some other states that are clearer one way or the other. This isn't very clear. It's a little ambiguous. So why doesn't that ambiguity make it an objectively reasonable mistake of law?
Certainly. And that other subdivision, 376-1A, that defines within itself that it applies to lights that are on from sunset to sunrise. So we have a provision that are for lights that are on all night long, your headlights and your taillights, and we have a provision that's for lights that are illuminated when you step on the brakes. That's clearly your brake lights. You can read these two statutes together. They're clear independently, and even when read together, they don't create ambiguity. There is one provision only that looks at brake lights. The other is not an umbrella provision. And to Your Honor's previous point about Hine, the language in Hine in the North Carolina statute was different for two reasons. It was not just all lamps, it was all originally equipped lamps. We don't have either of those pieces in the New York statute. So I want to distinguish the ambiguity that was inherent in the North Carolina statute, that it was both all and originally equipped. And what we have in New York is a subdivision that clearly applies to lights that are on all night long. Those have to be in good working order. And then we have brake lights. You have to have at least two, one on either side, which Mr. Pena clearly had. And other courts who have looked at this, the lower court, the suppression court, the Southern District of New York and US v. Moda looked at this exact fact pattern, a broken middle brake light, and they said, the law here is clear. The plain meaning is evident. You look to these statutes, and he was not in violation of them. And again, that's what this court did in Guthrie. They looked to this court looked to the applicable laws, the relevant sections of the VTL. There was no ambiguity. Of course, there were outside circumstances, but that's not what we have in this case. It's very simple. He was not violating the VTL. And in fact, in the people's letter asking for cert in this court, they conceded that VTL 375-40B is clear and that Mr. Pena was not in violation of the VTL. So I don't believe that this mistake of law is objectively reasonable given this specific issue within the VTL. I think the VTL very clearly defines internally.
So if we were to
which
disagree
applies.
with you and agree with the people's position that there is an objectively reasonable mistake of law, what do you think is the procedural aftermath of that?
I do think it's a bit complex. I think that, if this court were not to affirm both lower courts, the matter would likely go to the term, and then the people would decide if they would seek to bring this case again. But I would note also some of the language from last week's decision in Hinshaw, where this court said that we have to, when we're talking about a traffic infraction, we have to apply even greater scrutiny to prevent a police officer's badge from being considered a license to oppress. And so when we have a case where we're talking about an officer's mistake of law on a traffic infraction, this court has found the importance of using greater scrutiny in these circumstances.
Do you think Hinshaw then adds another layer to Guthrie? Guthrie was a violations case, wasn't it?
Yes.
So now we read Guthrie differently
I don't
because of
think so,
Hinshaw?
but I sorry to interrupt, Your Honor.
No.
I think it emphasizes the values that this court is looking to when we're making these determinations.
But in practical terms, how would that affect our Guthrie analysis?
In Guthrie, we have, right, the mistake was simply that we would never expect an officer to know the registration status of a stop sign in a grocery store parking lot. It's not a close call in Guthrie. The same with Estrella. We don't expect an officer to know the window tinting requirements in the state of Georgia. We would never expect an officer to know that.
But what about the facts in Hain, the Supreme Court case? What would you expect the officer to know there?
The officer is charged with knowing the law. That's what this court said in Guthrie.
So
right?
what is changed by Hinshaw?
I think that in terms of,
How we approach the mistake of law analysis?
I think it just emphasizes why we are doing this inquiry in the first place, and it's to protect people's Fourth Amendment and New York constitutional rights not to be infringed on.
So it's really not affecting it at all in terms of mistake of law analysis. Is where I think you're agreeing.
Yes.
And that really goes to an issue which we don't even necessarily need to reach at this point, which is what's the standard of knowledge for, whether it's probable cause or reasonable suspicion for a traffic infraction?
Absolutely. We don't need to reach that. The question is it reasonable? It's either reasonable or it's not. And it's not a reasonable mistake. Every court that has looked at this subdivision with these facts has found that it's not a reasonable mistake because the law here is so clear. The officer was simply mistaken.
So if it's a reasonable mistake, you have probable cause?
Sorry?
If it's a reasonable mistake, you have probable cause?
If it was a reasonable mistake of law, then yes. I mean, yes.
Thank you, counsel. Counsel?
Yes. Very
And
briefly.
counsel, you agree Hinshaw does not affect the analysis here?
In the sense that if we focus on the objectively reasonable mistake of law, no, it doesn't affect it. This would be clear probable cause based on the broken middle brake light. If we also then went the other route of, is it reasonable suspicion that the vehicle wasn't inspected properly, then Hinshaw, obviously, I think.
So if an officer is incorrect about whether or not one has broken the law,
Okay, yes.
okay, right?
Yeah.
But we say it's reasonable under the circumstances to have made such a mistake.
Yes.
That gives you probable cause?
It depends I guess, on the facts of the matter, whether it rises to the level of probable cause. I mean, in this case, it's a broken light. That's pretty much all you need. And for many of these equipment violations, and
I guess that's a yes?
Yes, Your Honor. Yes, absolutely.
Thank you.
Yes, Your Honor. To just briefly address the nighttime issue, once again, the brake light could also be a signaling device. None of these terms are really defined. It signals to the car behind you, you're stopping. There's no limitation in 376 that signals only work at night. To if we read it as a lamp, of course the legislator would want lamps to work at night, including a stop lamp so that someone can see it. So based on all of these readings or interpretations of 376, the officer's mistake was reasonable here. He had probable cause, and the evidence should not have been suppressed. And if there are no further questions, I'll yield my time.
Thank you, counsel.
Thank you.